and what are the issues related to Pmla. You must have seen so many articles in recent times about Prevention of Money Laundering Act, and there is so much of criticism of the recent Supreme Court judgment also. Let us try to understand all of them in a very simple manner. What is this money laundering in the first place? What is money laundering? Yes. Conversion of black money into white. Okay. And how this conversion takes place, because this is a topic very important for your internal security paper 3 and governance also. Last year also I think money laundering was asked in your paper 3, in your GS paper 3. It is how this money laundering takes place. How this money laundering takes place? You. For that you must have money also, right? Yes. Mutual funds, no. It seems you don't have money, that's the reason we don't know, right? Yes, it takes place through many ways. For example, you are sitting in Delhi and you want to send money to someone else sitting in, say, London, right? The Hawala agent is here in Delhi and another Hawala agent is there in London. You give this agent in terms of rupees or dollars, and this agent will give to the other person, the source, in terms of dollars, and they will charge commission from you. All this money is what we call unaccounted money. It will not be there in the books. Very popular way of money laundering. Here, you are giving a Hawala agent, go to old city. Here, even now also, almost there are at least 200-300 agents who will be doing this money laundering in thousands of crores of rupees. Sometime back, what happened? Sometime back, police, we are talking about the UPA government. Police, as usual, they were doing some kind of ordinary checks in the Chandni Chowk area, where you find all of them. Suddenly, they got a huge amount of money, around 20,000 crores. That was laundered. Immediately, the finance minister was Pranab Mukherjee. In the middle of the night, he was informed, and the media was also getting information about this. Suddenly, it was realized that it was nothing but Congress party money. Yes, sir. It was nothing but Congress party money. Immediately, Pranab Mukherjee met Prime Minister. Both of them met Sonia Gandhi, and immediately the police were asked to close their eyes, because that money was to be sent by the Congress party to various state units to fight elections through Hawala route. Right? This kind of money laundering takes place, as we discussed in our yesterday also. It was mostly black money in elections. It takes place. You give your money to the agent here in Delhi, and other agent in say some other city, they will pay that money to the source, and in the process they will charge what you call commission for it. At the global level also it takes place like this only. These Hawala agents will be there. This is one way of money laundering. And what are the other ways of money laundering? For example, I'm an exporter and importer. What I will do is that there are two things: undervoicing and over invoicing of exports and imports. For example, I am exporting only say 100 crores, but I will send an invoice of 1,000 crores to the person in other country, foreign country, and he will send that money into my account, and I will send the cash to him, through Hawala routes. Are you getting the point? So what I am doing is I am converting my black money into white money. And another thing here you have to remember is that here if it is coming through export and other things, normally the taxes will be less. Government gives the tax incentives. The next way of money laundering is, again as usual, I will send my money to other bank accounts in foreign countries through Hawala route, and the same money will come back to country in the form of foreign investment. And foreign investment to FDI is not taxed. So this is how I will be doing it. And another way is that I will send money through this Hawala route, and they will deposit small amounts in different banks. In different countries around the world. From there, those banks again, it will come back to me. And it becomes almost impossible for enforcement directorate to find out where exactly is the source of money. For example, the present Chief Minister of Andhra Pradesh is there, Jagan Mohan Reddy, and ED and all these CBI, all of them have said that he was involved in this kind of corruption scams worth around minimum 50,000 crores and maximum 1 lakh crores. And they still could not find the source of money, because the money was moving from one tax haven to the other haven, from another country to the other country. It will go to the fifth country, then ED will go and ask them. They will say that we will not give any information about our customers, because the privacy laws are there in those countries. Especially you have the Swiss banks. Recently Swiss banks have said that they are willing to give the names of the account holders if the countries demand it. India never said that we don't want any kind of information. Let them have it. We are a country that believes in privacy of our rich people, so we don't want any kind of information. On the other hand, we have these small islands, what we call combined all together. All of them are called West Indies now, cricket team. In all those islands, the governments are just like Old Rajnagar, one government, New Rajnagar, another government, in between Shankar Road, third government. Like that, small countries. And they will allow you to keep any amount of money. They will not ask you for any source of funds, and you will transfer all those funds. And then countries are signing what you call bilateral treaties, tax treaties. For example, if you are paying tax in one particular country on a particular amount of money, you don't have to pay the tax in other countries. So that is the kind of agreement India has with small countries like Mauritius. And that is the reason why sometime back Mauritius was the country which has provided India with maximum amount of foreign direct investment. All our businessmen, they would through money laundering, they would take their money to Mauritius, and they will pay the taxes, 5%, 10% tax there, and it will be brought back to India in the form of foreign investment. And this is one way of money laundering. And then there are other ways, especially these drug money and terror money. All these things are part of, again, as I said, your General Studies paper 3. And most of this drug money is transferred through what we call fictitious account. The account is there only for the namesake, otherwise there is no identity of the person. Money will go, that account will be used for only transit purposes. One account, money comes from another account to this account, from this it will go to other account. And the problem is that even if in the entire whole chain process, even if one single bank says that they will not provide the information, there is a enforcement directorate or other other investigative agencies cannot do anything. And this money laundering had become a major issue, especially after 2001 there's attacks on United States of America, terror attacks on United States of America after 2002. And that is 2001. That is the reason why countries around the world had come together and they had come out with various what we call laws, rules and regulations to prevent money laundering. Accordingly, India also had come out with this Pmla, Prevention of Money Laundering Act 2002, right? Yes. Hawala. Hawala means hawala. Hawala transactions means basically unaccounted money transactions in cash. Unlawful. Beyond that, nothing else. Someone can tell me the meaning of hawala in Hindi? Hawala, is it a Hindi word? Hindi? Urdu. Okay, whatever it may be, what is the meaning? Okay, through a medium, right? Right, that is what? Hawala means a medium through which you are laundering money. So why this money laundering had become, as I said, a major issue is that it had become a major issue because after 2001, it was found out by most of the countries around the world that the terrorists are using this narcotics, drugs money for financing those terror activities. That is the reason why, at the global level also, we had to come out with various legislations. What is that legislation that can, punish the countries for not taking strict action against this money laundering? The question that was asked again in your internal security before last year. Yes, right? So Pakistan right now is in the grey list only. Yes. Yeah, that is what right now they are being implemented in a more effective manner. Why? Because as I said, global terrorism. Global terrorism had become a major menace, and mostly it is the drug money, narcotics money, and all this illegal trade money is being used to finance these terror activities, especially Golden Crescent, which runs from Afghanistan to Southeast Asian countries. That money is used. That is the reason why in 2002 we have passed this Money Laundering Act. But the problem is that after 2002 we kept on making more changes to Money Laundering Act for a period of time. And recently the changes that we have made to Money Laundering Act are the ones that had become controversial, and also the fact that the Supreme Court had come out with a judgment last month in July accepting the amendments made by the government to Money Laundering Act, which were considered what we call illegal by most of the constitutional experts. For this, let us go back to what we have seen as part of administrative law. Right? What did we say about administrative law? Administrative law gives a huge amount of discretionary powers to officials, and there is every possibility that this discretionary power can be transformed into arbitrary use of power. Another thing is that, as we discussed, administrative law is a negation of the concept of rule of law. Why? Because this PMLA and other administrative laws, what is common to all of them? They violate the first principle of administrative law, the first principle of rule of law. What is the first principle of rule of law? You can be proved guilty only by ordinary courts in an ordinary legal manner. That means you are innocent till you are proved guilty. And what happened is that in recent times, this government had made many changes to PMLA. Let us see what exactly is the problem there and why it has been opposed by most of the constitutional experts. First and foremost, according to the cases that are filed in the Supreme Court, the first major issue is regarding the passing of the bill, which we shall be discussing later also as part of Parliament. The government of India did not have majority in Rajya Sabha. They did not have majority in Rajya Sabha. So the government of India has passed this PMLA amendments as a finance bill, what we call as a money bill. As a money bill. So the first contention of the petitioners is the government of India has passed PMLA amendments as a money bill. And what is so unique about this money bill? Rajya Sabha has only limited powers. Rajya Sabha has only limited powers. And the government did not have majority in Rajya Sabha at that point of time in 2016 when these amendments were passed. It did not have majority. So that is the reason why it was passed as a money bill, finance bill. And this was questioned by the petitioners in the Supreme Court. That is what we study in administrative law. Judiciary can strike down any administrative law for procedural ultra virus. Procedural ultra virus means if a proper procedure is not followed, then judiciary can strike down that particular law as ultra virus. In this case, according to the petitioners, this PMLA does not come under money bill. The government has wrongly categorized PMLA as a money bill to escape Rajya Sabha voting. That is the first contention. And Supreme Court already had Supreme Court had already set up a constitutional bench of 5 judges to look into this money bill. And of course, the judgment did not come even now. It was set up long time back. It was set up long time back. So the first contention here is, how you have passed this Pmla amendments. They said that it was completely unconstitutional because of procedural ultra-virus. Right? This is the first contention of the petitioners. Second one is, it violates fundamental rights. Article 20. It violates fundamental rights. Article 20. What are the Article 20 says? Due process of law must be followed. Due process of law must be followed. Before you are pronouncing any person as guilty, if you are calling a person guilty of committing a crime, it should be done as part of what you call due process of law. That is what we studied with Dicey, the first principle of rule of law. A person has the right to claim innocence till he is proved as guilty of committing a crime by an ordinary court in an ordinary legal manner. And what the petitioners have claimed here is that this violates Article 20, the due process of law. Why? Because under the Pmla, Enforcement Directorate has the power to call you guilty. It says that you are guilty without completing the investigations, without judiciary pronouncing the judgment. You are called guilty. And then what happens? The next one is becomes more curious. And it says that the burden of innocence is on your shoulders. You have to prove that you are innocent. The government says that you are guilty, and the burden of innocence on your shoulders. Right? The burden of innocence will be on your shoulders. You are called guilty, and the burden of innocence will be on your shoulders, which violates the basic fundamental right of the citizens. It says that you have indulged in money laundering, and then we are calling you guilty. We will punish you. Now prove your innocence. This is where again it was questioned by the petitioners. Right? Next problem is retrospective legislation. Retrospective legislation. We'll talk about this retrospective legislation today also as part of our parliament. For example, these amendments normally, as we say, is that whenever a law is implemented, it should be coming into either with immediate effect or at any specified date decided by the parliament or the government. Under this Prevention of Money Laundering Act, it comes into effect retrospectively also. That means even in those cases when the law was not existent, for example before 2016, it can be applied. At that point of time, it was not called money laundering. Right? In 2015, you have done something. At that point of time, it was not money laundering. At that point of time. Now, I can punish you for whatever you have done in 2015 when the law was not there. Retrospective. As we have discussed, if you remember, I gave you this example also. The example of the traffic lights. The government has said that we have the CCTV camera recordings. When the traffic lights are not there, you have violated, so you pay the fine. Right? And that is what exactly another problem with this money laundering legislation. It comes into effect in a retrospective manner. This is another problem with Pmla. Next problem with the Pmla, next issue with the Pmla is under this Pmla, Enforcement Directorate will file their first information report. It is similar to what is called FIR. It is similar to FIR. Enforcement Directorate will file their initial investigation reports. And this report filed by the Enforcement Directorate will not be shown to the accused. It will not be shown to the accused. For example, Enforcement Directorate is filing a report against me, in the initial investigation report, first information report, something like that. And this report will not be shown to me, and Enforcement Directorate says that prove your innocence. They will not tell you why you are guilty, but prove your innocence. They will not tell you why you are guilty, and then they will say that prove your innocence. That is what. And then next problem is that they can arrest you on the basis of suspicion without any FIR. They can arrest you on the basis of suspicion without any FIR. And they will say you are accused, and then keep you in custody for any length of time. They can keep you. Another important aspect of this legislation is that they can arrest other people whom they think are connected with the crime. They are not directly involved in the crime. You are not directly involved in the crime, but you are connected to the people who have committed the crime. They can arrest those people also. And they can arrest those people, and they can force them to become a witness also, without knowing what kind of crime they have committed also, without knowing. And on top of it, if it is doing a great job, we can understand. In the last 8 years, the conviction rate of Enforcement Directorate is less than 1%. In the last 8 years, the conviction rate of Enforcement Directorate is what we call less than 1%. Maximum number of cases are filed against only political opponents of the ruling political party, right? And why it had become controversial? Because all these amendments that the government had made to Enforcement Directorate have been accepted by Supreme Court in I think 27th July judgment. Supreme Court of India had come out with a judgment. A 3-member judge of the Supreme Court had come out with a judgment upholding all the amendments made by the government of India in empowering this Enforcement Directorate. All of them have been upheld by the Supreme Court. And that is the reason why for the first time in the history of judicial history of our country, the Supreme Court of India is willing to review judgment given by some of its brother judges. Chief Justice is willing to take the. Why? Because normally when once the Supreme Court comes out with a judgment, that it is not a single judge judgment, it is a multi-member, 3-member judge judgment. Normally Supreme Court will not review its own judgments. But within less than 1 month, Supreme Court of India has agreed to review the judgment of these judges. Why? Because the judgment is flawed legally, morally, procedurally, and otherwise also. Why? Because it gives huge amount of powers to Enforcement Directorate without fixing any accountability. It is simply a violation of the concept of rule of law. Right? It is simply a violation of the concept of rule of law. For example, Enforcement Directorate has identified that you are staying in a house which was brought through the proceeds of illegal money. Right? You are staying in the house. That means you will be made the culprit. And they said that you are guilty. Now prove your innocence. You say that I am only staying in the house, I am not related to the house. They will say that no problem. First prove you are guilty. That is how it is. And this house, let us assume that you have purchased this house in 2015. They will say that in 2015 you have purchased this house using illegal money. The amendments were made only in 2016. In 2015 it was legal transaction. By 2016, because of the amendments made to Pmla, it had become illegal. And they will say that then you will also have to prove your innocence. This is where exactly the problem with Pmla. Right? Tomorrow we will continue with more controversial aspects of Pmla, and we will go to something else also. Right? These are all very, very important. Tomorrow we'll look at a little bit more legal aspects of PMLA. Right? As I said, it is very important for your public administration paper 1, Indian administration, quality governance and internal security. Yes. Principles of natural justice. Yeah. What is it? Against the principles of natural justice. That is what? What is the most important principle that it has violated here? You have the right to claim innocence till you are proved guilty. Here PMLA says that you are guilty. Now prove your innocence. Right? I am saying that you have committed a crime. I will not tell you what is the crime you have committed. I will not tell you because the investigation report will not be given to you. And I will say that now prove your innocence. Very good. This is it looks, Hitler looks like a Democrat under PML. Right? So that is what it is. As I said, tomorrow we will look into more technical aspects of PML. Right? I have just told you in general what are the basic issues. Tomorrow we'll look more into the technical aspects. So proceeding further, yesterday we were discussing about Parliament. Right? We have seen all the reasons for declining stands of Parliament. We have seen what are the major electoral reforms that should be implemented. And we are looking at all other reforms to make the functioning of Parliament more effective. So first and foremost, we have said that let the number of days Parliament has to meet be fixed. And if for any reason, if the Parliament fails to meet for those number of days, it should meet for extra number of days, and for those extra number of days, MPs should not be paid any allowances, to fix accountability on the part of our MPs also. Then we are talking about the role of the Speaker. As we have said, entire impartial, unbiased functioning of the Parliament depends only on the role of the Speaker. Ultimately, it is the Speaker who has to ensure impartial functioning of our Parliament. Why British Parliament is very effective? Because Speaker. And how the British Parliament and Speaker is elected? The Speaker is elected by both, with the consent of both ruling and opposition parties. In the first round of taking up the names for the office of the Speaker, you require minimum MPs from opposition parties to support your candidature. Then only you can file your nominations also. By the end, you need the entire support of the opposition also to become a Speaker. That is the reason why Speaker is elected in an impartial and unanimous manner. And once a person is elected as Speaker, he will be the Speaker for the life. Once a Speaker, always a Speaker. He will be nominated for the next House, and he can continue to be the Speaker till the entire House of Commons agrees. And his continuation depends on his own impartial function. And as we discussed, in India also we spoke about some of these reforms. The first Speaker of our Lok Sabha, G.V. Mavlankar, he wanted to uphold the highest traditions of our Parliament, and he said that he would be resigning from the Congress party. But that did not happen with other speakers. On top of it, anti-defection law had given extraordinary powers to our speakers. Anti-defection law, it had given extraordinary powers. And we have seen various instances wherein these extraordinary powers have been misused blatantly by the speakers, because anti-defection law was framed in such a manner that it had given extraordinary powers without any accountability. There is no constitutionalism, and the role of the judiciary is post-mortem only, and the judiciary cannot normally enter into the powers of the Speaker also. Yesterday we have seen what kind of changes that should be made to the anti-defection law also. Now, what are our suggestion for the office of the Speaker? We should follow the British traditions, for electing the Speaker. Right now, the Speaker is always from ruling political party, and the ruling political party selects one person as a Speaker, and automatically he becomes a Speaker, because normally ruling political party has majority in the Lok Sabha, and this Speaker always acts more as the representative of ruling political party than the custodian of the House. This is where the problem is. I gave you the examples, wherein Meera Kumar, how she had saved the UPA government. Manmohan Singh government, when the opposition parties introduced no confidence motion. Once no confidence motion is introduced, the speaker should not have any discretionary powers at all. The speaker must verify the no confidence motion for its validity and should introduce the no confidence motion on the floor of the house by suspending the normal business of the house. And how did the speaker do? What did the speaker do? She has used an excuse, that is saying that the house is not in session. And the speaker instigated the ruling party members to create disturbance on the floor of the house, and on the basis of the excuse that there is a disturbance on the floor of the house, she has not allowed this no confidence motion to be introduced also. So she has saved the government. That is how Speaker's office has been misused. So ultimately, what is the solution we are offering? Of course, these things will never be implemented. As we have said, that the speaker should be elected with at least 50% of the opposition parties members accepting the